7 copies of the list of all responsibilities we have.
Sure.
And your, I got mine marked up, so I'd like 7 copies of the audit report response that we put together.
Sure. Okay.
And then I'd like 7 copies of Marlon's letter.
Are there many?
Welcome to the Westline Anytime Conference Center. If you press star. Please enter your moderator code. Your call has been placed in conference.
Hello, this is Tom.
Hello, Judge Barlin. It's Kevin Kennedy, and we have in Madison Judge Vokey, Judge Fraley, Judge Nickel. A room full of people.
Also, Lamelas is on the phone. Is the road noise really bad? I'm going to mute it so as to keep it down. Can you hear a lot of?
We're not hearing it.
Oh, okay. And then what I wanted to ask is when I'm in the car and my husband is driving, but when we come to an end of the open meeting, there's usually a little bit of a break. I don't know if Wisconsin Eye is there to take that down. And then we're going to pull over and I'm going to my husband is going to leave the car so that he's not listening in to anything I might say during the close. I'm just going to need a little bit of time doing that for the car.
Are you gonna stop the car?
John Frankie is on, so, can we review who's there in person and who's on the phone?
Sure. On the phone, we have Judge Lamalis, Judge Frankie, and Judge Barland, all of whom are now connected. In person, we have Judge Freilich, Judge Vokey, and Judge Nickel. Judge Barland, since Judge Freilich is the vice chair, I want to ask him to take over. Madison?
I think that'd be a good idea.
Okay.
Thanks, Tom.
Then, Judge, if you want to call the meeting to order, we can.
Meeting to order now. All 6 members of the board are present either in person or by contact. And have the notices been given properly?
The proper notices have been given for the meeting.
Okay.
Notice for a teleconference meeting.
Well, then we go to the minutes of the December 16th meeting. Are there any corrections needed in those minutes? If not, is there a motion to approve them?
So moved.
Second.
Motion by Judge Vokey, seconded by Judge Nickel.
Is there any further discussion? Hearing none, we'll take a vote. All those in favor signify by saying aye.
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 Any opposition? Unanimously approved.
Okay.
Okay, we now come to the most important part of the January meeting.
That's right. We now are going to select the board officers. I have reviewed with Judge Freilich, and despite his objections, all 6 members' names have been placed into the vase that we'll do the drawing from. And Judge, you get.
I get the draw.
You've got 2 of them.
Oh, there's only one.
Oh, 2 of them?
No, there's only one.
Oh, fold it that way.
Judge Nickel is the new chair.
Well, it's about time.
I ducked it for 5 years.
7. But who's counting? Okay,
Come over here. Judge,
Yeah, you can go ahead.
now we'll draw for vice chair. And Judge Lamalis is the vice chair. There isn't that much vice on this board, Judge. I said that much. It doesn't mean there isn't any. Finally,
It depends on who you're talking to.
Finally, we'll draw for the board secretary. And Judge Barland, in your final months on the board, you will be the secretary.
Okay.
Now, the reason we draw all 3 names, even though the statute only requires that we draw the chair, is in case there is a vacancy in the position of chair, then we've done the drawing for the chair, and the vice chair moves up, the secretary moves up, and then we would redraw for secretary. So it is up to Judge Nickel and Judge Freilich how you want to proceed with the meeting.
You can proceed.
We next move to personal appearances.
2 points of order here. One, we have a request to make a personal appearance from a representative of the Association of Wisconsin Lobbyists. We normally limit the personal appearances to individuals with ballot access issues, but in staff's discussion, we thought maybe board would make an exception. They want to make one comment about the proposed legislative agenda dealing with changes in the lobbying law. We also have a personal appearance request from an individual who's challenging ballot access, and board members have received the materials. That person's going to call in. They're in the middle of a court appearance, so we'll have to take things out of order when that
So those are the only two.
Those are the only two, and if the board is willing to grant the Association of Wisconsin Lobbyists the exception from the normal limitation, we can proceed with having Ms. Jody Jensen.
Could I address that?
Sure.
The notice that went out to people indicated it was only from individuals with issues concerning ballot access. And had it been wide open, people here who didn't show up simply because of the notice that we gave them. So,
I'm having difficulty hearing the speaker.
I'm sorry.
So am I.
The notice that we gave indicated that there was only going to be speakers on ballot access. And now there's a request for somebody to speak on a different subject. And I understand it's anticipated that it'll be short, but I'm not quite sure that that's fair because there may have been other to be speakers here today, but they didn't show up because we were limiting it to ballot access. So I, for one, would oppose allowing somebody to speak except on ballot access.
This is John Frankie. Does the speaker have a written submission?
No, but they would be in a position to do that.
I didn't mean to interrupt the motion, if that's what we have, but I just
There's no
wondered if
motion,
there was
it's just-
going to be a written submission along with the request to make a statement.
We're talking about the agenda item L, the report on ethics changes in the lobbying law. You've been on the committee, Judge Frankie and Judge Lemanis. Are you expecting this board to take action on that today?
It's Volke and Frankie that discussed this and submitted some recommendations.
Oh, it was Volke, it was you and not Lemanis.
Yes, sir.
Oh.
But that's got nothing to do with the reason for my comments.
No, I understand that, but from my knowledge, if we're going to take action on the recommendations today, and we have someone here that wants to speak on them, it seems to be reasonable to hear that outside information.
I would support that, and if that's a motion, make it my motion.
Is there a second? To allow the individual to speak on the lobbying law.
I'll second that.
Any further discussion? All in favor?
And
signify-
as I understand it, Judge Freilich, the point that you're making is if we take no position, anybody else who may want to speak on that issue could appear at a subsequent meeting and be heard.
That's correct. But if we're going to take action today, then I think we should have as much information as we can have. So you've heard the motion. All those in favor say aye.
Aye.
Opposed?
Aye.
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 Opposed? Aye. It's 5-1.
Motion carries. Ms. Jensen, come on, you can leave that still here. And thank you. Do we have a microphone that?
There's one there.
Oh, this one?
Yeah,
Okay.
that's the important one. That one goes to the board members in the room. The other one is Wisconsin Eye.
Okay. My name is Jody Jensen. I'm an attorney at Godfrey & Kahn. I work with Mike Wittenweiler, who's appeared before you a number of times. We represent the Association of Wisconsin.
You're going to, excuse me, I'm sorry. Could you speak more into the mic? I'm sorry, I apologize.
Sure, sure. Is this better?
No, not really.
Slightly.
We're switching microphones.
Okay.
We'll see if that helps.
No, uh-oh.
Okay.
How's that?
Much better.
Okay.
That's better.
My name is Jody Jensen. I'm an attorney at Godfrey & Kahn. I work with Mike Wittenweiler, and we represent the Association of Wisconsin Lobbyists. He's appeared before you previously on this issue. This is regarding the proposed changes to Chapter 13, which were amended by the legislature in the last session that relate to lobbyists furnishing campaign contributions to elected elected officials soliciting contributions from lobbyists, which the board dealt with, I believe it was in April, because the statutes as drafted, there was some question about the effect of those changes and what was actually achieved. So the board made an interpretation at that time that the Association of Wisconsin Lobbyists agreed with, and members are happy to abide by. So this recommendation that appears to return to the language pre-Act 153, I think it was, from the 2013 session, which prohibited lobbyists from furnishing contributions except for personal contributions and other contributions within that window. And that is the language that the Association of Wisconsin Lobbyists has had concerns with and debates with the staff about for, I think, about 8 years or so, predating my time at Godfrey and Kahn.
Could you tell us what number you're referring to?
It's item 2C on page 136 of my, is that correct?
Yes.
Thank you.
So,
We have the item number again?
It's item 2C on page 136 of the open materials is the language.
Oh, 136, I got it.
so what it appears to do is go back to the legislature made its changes and before the board made its interpretation last spring. And really all we're asking is, because this has been an important issue and an issue of much debate over the years with the Association of Wisconsin Lobbyists, is to take some time and kind of work through it with the legislature and with our association if staff and the board is willing to do that, rather than returning to a statutory scheme that prompted legislative changes in the first place.
Anyone have any questions?
No, sir.
Ms. Johnson, I'm not sure that I understood correctly. You're saying that you agree with going back to the legislature and asking for clarification? Is that what you said?
No, that's not what we're asking, but if the board decides that clarification's needed, we don't think this proposed language gets us where we'd like to be at. So if that's the direction that we're heading, is to go back to the legislature based on the board's recommendation, then we'd like the chance to kind of work through this language with you and try to reach some common ground about what we're trying to achieve and how we achieve it.
Thank you.
Other questions?
My only comment, just to put things in perspective, is designed to take the existing law as it was amended and simply restructure the statute. So if you see some language changes there, one of the things I would suggest is maybe you come back with some suggested language on that provision. The
Okay.
idea when this was drafted was to take what we have now, according to my discussions with staff. I guess that there's some dispute about that. So it would be helpful to have your suggested changes.
Yeah.
Because if the board chooses to take action, it would.
I will talk to Mike about that and we'll get something to you.
Thank you for appearing.
Thank you, I appreciate it.
Okay.
We don't know when that phone call's coming in on the other appearances.
We don't, we'll get a beep on the line and they'll join us.
And that's part of G.
Kevin, I think we have one person who wants to appear on the ballot.
Right, but that's part of the same case, that's under item G.
Okay.
So that's when we would normally take them.
So, Mr. Chair, until we have the personal appearances related to ballot access, if we could proceed with maybe the other sections on the agenda in the open session. The next would be item F.
Delegation of certain authority as to the director and general counsel.
These materials are found on page 15 of your board materials, and this is an exercise that the board engages in every January. The statutes, the board's general authorization statute permits the board to authorize certain activity that would be done by the board to be carried out by the board's general counsel. It's been modified a number of times over the years. Some significant modifications last time. What you have in front of you is this, as the recommended motion, is what the board approved in 2014. with respect to these actions. The normal practice is that when, in most cases, anything that is delegated to the Director and General Counsel to take action on, the board first, the Director talks with the board chair first to determine, is it an issue that requires full board weighing in, which case a special meeting would be called. Otherwise, the board chair will sign off on that. In the board chair's absence, as Judge Fraley can attest to, the vice chair will act in these cases. There are a handful of situations where there is no consultation directly with the board chair. These are primarily administrative, much more administrative tasks in this area. But the board's practice is to review this delegation every January, or if there's a change in the position of director.
One of the,
Go ahead.
I'm sorry.
Go ahead.
Well, one of the areas about which I had a concern last year was the delegation regarding intervention in court action. And I think I got talked out of that concern last year. I can't remember the specifics on that. But as I read it, it's one of the things that really jumps out at me as being a delegation of some concern.
And I think the position we articulated last time, Judge Lemalis, was that these are often very quick decisions to be made, and that because the director talks with the board chair, if we think it is, it's a question of recognizing it is significant, but the idea was to provide flexibility for the agency if we have to take action on this. And so the idea was let the board chair make the decision whether it should go further involving other board members in terms of consultation on this. Intervening in an existing action often doesn't come up that often, but there are other decisions that happen as litigation is proceeding where we have to consult with counsel, and board members are generally briefed at meetings on pending litigation issues. But I think the main reason we have kept it was the recognition that there would be the possibility that, for example, we might have a decision where a court has ruled to keep someone off the ballot, and the board would not necessarily be a party, although it has a right to be a party, and that's going to move fairly quickly. And the board, because of its experience and expertise, would want to make sure that the court had the view of how that law is applied in state cases and how local elections to do that. So that's an example of one where there might be very quick action required.
Could you give us an example of any intervention that you participated in under this delegation of authority?
The one that I can remember most clearly involved, actually it was a Court of Appeals case and involved the former Elections Board, where it was our belief that the circuit court got the application of the law on a recount incorrect, and we applied to present a brief to the Court of Appeals, which actually there were two of these cases where the Court of Appeals then took that into consideration in our briefing.
So you could say that it hasn't been used since the reconstitution of the board.
That's right. Under the GAB, we have not intervened in any pending cases that I can recall.
This is Judge Barland. I share Judge Lenalis' concern on recommendation 1, and I am prepared to move to amend that to accept in an emergency. Or another way of stating the ability to convene
The full board?
lack of time to convene a full board session.
Is that a motion, Judge Barland?
Yes.
Is there a second?
I would second that.
Is there further discussion? Do we have the exact,
Read.
say that, except in an emergency, when there is a lack of time to convene a full board session.
When there is an emergency and a lack of time for a full board session. Is that right?
Except in an emergency, when there is a lack of time to convene a full board session.
No, I cannot hear the speaker. Was that Jerry?
That's Reed. I'm
It's
sorry.
Reed. He's got his,
Reed?
Yeah, I've got.
The proposed amendment, as Reed has it, is except in an emergency where there is a lack of time to convene a full board meeting.
And this is number 1 on page 18.
I think this is Jonathan, I think grammatically, that is not what you mean, because the way this is phrased is that it delegates authority to intervene. And if you say except in these cases, that's exactly the opposite of what you want. You don't want the word except. I think what you mean to say is delegates the authority to intervene in these actions when there is not.
Well, then you can say.
Unless there is an emergency.
Then you can say, it's just a question of putting the except after the introductory clause.
I think as to the language.
so can we have the final best language?
To intervene if there is.
In the case of an emergency where there is a lack of time to convene a full board meeting.
Right.
Has everyone got that? Is there any further discussion?
Yes.
Any further discussion? If not, let's have a roll call on that.
Okay. This is on the amendment.
Yes.
Judge Lemalis,
Aye.
Judge Barlin,
Aye.
Judge Frankie,
Aye.
Judge Nickel,
Aye.
Judge Folke,
Aye.
Judge Freilich.
Aye.
The motion as the amendment to the motion carries.
I have a question now on number 5. The language is to authorize the non-appointment of an individual who is nominated to serve as an election official. I'm troubled by the word non-appointment. I've seen that I don't know what it means.
It's statutory language, Tom.
That's correct. It comes directly from the statute under 7.30. When a political party nominates an individual to serve as a first choice nominee, and the governing body makes a decision not to appoint that person, and the statute uses the word non-appoint, that decision can be reviewed by our agency, and that's why we use the word non-appointment.
Any further
I'm
discussion?
still having difficulty understanding what your function might be then.
Well, if a governing body decides that it does not want a particular individual to serve as an election inspector that has been nominated by a political party to serve, and the political party has indicated that that is a person that falls into the category that you have to accept them, the decision of the governing body can be reviewed by this agency. It has to be on the basis that the person doesn't meet the qualifications to serve, or whose service on the board as a poll worker would be counterproductive based on, say, a history of that individual refusing to follow.
Well, if I understand what you're saying, and I realize now that you're using statutory language, but does it mean to authorize or to disqualify an appointment who is of an individual who is nominated to serve?
The statute requires a standard of good cause for non-appointment and states that the municipality may request the board to authorize non-appointment. And then the board may permit non-appointment for cause demonstrated by an appointing authority. So in the cases Director Kennedy was saying where this applies where there's a first choice nominee of a party. And the appointing authority, the municipality would like to not appoint that person for good cause. They may request the board to authorize non-appointment.
Okay.
Any further discussion on that issue? Does anyone else have any comments on these delegations of authority?
I do. I'm sorry.
It was John Frankie, and I had a note about both 1 and 10, and we have addressed 1. 10 concerns decisions that are made during litigation, and I was going to include that in the discussion about 1, but I am not recommending or moving to change 10. A whole range of decisions could come up in terms of conferring with litigation counsel. It could be something as simple as extending a deadline for a brief to be filed. And this is all subject to the consultation with the board chair and judgment by Kevin Kennedy and the board chair about whether it's something that the board needs to be participating in. It could obviously be very major, come up suddenly in litigation, but also many minor decisions. So I'm not asking that 10 be changed.
Judge Lemaes, then, you have something?
Oh, yes. With respect to number 6, which is the contract authorization for some 100,000 or under. If I recall correctly, last year when we took this up, last year there may have been no dollar limitation, and we came up with this $100,000 limitation, and with the consultation with the chair. And I was just wondering if Judge Barland or Kevin Kennedy could tell us something about how frequently this right to enter into contracts for sums under 100,000, how frequently that comes up. Since $100,000 is still a pretty substantial sum of money. I think I had proposed a lower sum, and we ended up with $100,000.
Well, the only time we discussed going over 100,000 was the contract for the voter ID information campaign. There were a handful of decisions under 100,000. Most of our purchases come off of a state contract, so that they wouldn't even fall into this category. There are very few decisions that would have been prompted under the 100,000. The one where I did consult with Judge Barland was back in the fall of 2014 to discuss reopening the contract that we had already engaged in to do the voter ID and public information campaign, which then subsequently was canceled based on the court's decisions.
Okay, I remember now. Yeah, that's one of the we talked about.
You're saying, Director Kennedy, that if it's something that is a purchase under the state purchase program, that this doesn't apply?
Well, it would if it's over 100,000, but I said the bulk of our purchases that we make, now if we had to extend our lease, for example, I'd be talking to the board chair about it, because our lease would be over 100,000. But right now, we don't have a lease to negotiate. We have, the lease is in place for another 3 or 4 years. But most of the we make tend to be for supplies or services that you have to buy off of a state contract, and they are under $100,000.
Well, my concern is a contract signed, I believe, by you regarding the spending money for design of the ballot that caused all kinds of controversy not too long ago.
There was a...
Now, if we would have been informed of that before the contract was signed, we might have had some impact on not going forward.
Well, actually, except for the fact that it involved the ballot controversy is an incorrect representation that's been out there. There was a contract to evaluate the usability of our website for military and overseas voting, our MyVote website. It was to train the staff on usability concerns. That individual also consulted with us as a contract, gave us about 5 hours of usability comments dealing with ballots, but the primary purpose of that was not about ballots, but about how the website was designed and how to apply usability principles in general to websites. But that was a $25,000 contract. And that's an example of one. It was under 25,000.
I understood it was 19,000, that's my recollection.
That was 24 something.
Well, I think that the contracts that, I think we should know about contracts that are going to be entered into. I think that's a responsibility of the board. You can sign the contract, but we should be notified in advance what the contract, you've got language here that says, the Director General Counsel shall also report at the board meeting immediately following action on the delegated authority, the specifics of the action taken, the basis for taking the action, the outcome of that action. Now, does that relate to everything on this list? Anytime you take an action?
For the delegated authority, it relates to just about everything, yes. There are, yes.
So we're getting these reports after the fact always.
Right, but in most cases, there's consultation with the board chair. There are a couple of exceptions. One exception, for example, is when a municipality asks for extension of voting, asks not to use their voting equipment, but to use paper ballots. Municipalities at every February primary ask for that authority. We have one now from the city of Marinette. That's one where we, the way this is drafted, we don't consult with the board chair on that one.
Well, I have an amendment to that section 6 that says as follows. To sign contracts on behalf of the board, except as provided in Wisconsin Statute Section 505(2)M, and that 10 days before signing any contract for which there is no reimbursement to the GAB from a third party, the director shall give written notification to each member of the board, which shall include a copy of the contract, the specifics of the action, and the basis for taking the action.
Is that for any and all contracts, or
Yes.
I didn't catch?
Yes, for all contracts.
And the only
I'm
exception,
really,
The only exception is if you're working with a provider of electronic equipment, voting equipment, we get reimbursed for that.
and is there, what if they're buying, I don't know, what if it's an order for paper clips? Is that excluded? Maybe I didn't catch all the language.
It's not, nothing is excluded.
let me ask a question of clarification. Sherry, when we buy office supplies,
We buy office mandatory state contract.
but we don't sign anything, we just,
Well, sometimes
we
we
sign
sign
a
a
per-
purchase order, which is a contract.
okay.
So there are some.
So
For
Xerox,
our IT services, we write a purchase order for that. For our
Right.
temporary services staff, we write a purchase order for that. So are you considering off of the state contract? I'm not sure if you're considering that purchase order a
well,
contract.
that would be an interesting scope, though. I mean, contracting for temporary services, such as the people who do accessibility audits, contracting for the IT consultants,
Correct.
those are in a different scope than buying Xerox paper, or buying other supplies to keep the office running, or and maybe somewhere in between that is leasing a new photocopy imaging machine.
or buying computers, or upgrading our computers, or hardware or software needs.
I share
Purchase
Judge
off the
Freilig's
contract,
concern, but on the other hand, I don't want to know about paper clips and light bulbs and
I
stuff
don't either,
like
but I
that.
didn't know how to write that to avoid that. Could we,
I just,
could we set this, this one paragraph aside and address it at the next meeting in March?
Sure, and we can give you an example of the types of purchases we make and the categories.
Okay.
And the types of purchasing allowed, because obviously state agencies have a fairly regulated purchasing process.
That would be good.
Okay.
I just wonder if there's a dollar amount that would satisfy the concerns so that we could deal with this today. I share Judge Freilig's concerns. I mean, I brought this up last year, but I just wonder if there's a dollar amount that we could live with, so that we could resolve it.
Well, what about if we modified it so that we would not have to approve contracts for office administration? Which to me would include LTEs, it would include paper clips, it would include Xerox paper, it would include upgrading the computer systems.
I don't know what would be injured by approving the rest of the delegations at this time and setting over 6 till we get more information and can work out a proper wording.
I'm good with
Was
that.
that Judge Freilig?
Yes.
I'm good with that.
In the meantime.
Anyone else have any problem with that?
My only question, Judge, is in the meantime, how should we proceed regarding contracts?
Between now and March 4th.
With a new chair.
Yeah.
Well, I would accept that as a motion. I'll make your motion to set it over. And
in the meantime, we'll go under the rule that's set forth here until then.
right,
I can live with that.
okay.
I'll second the motion.
Any more discussion? Does everybody understand the motion? All those in favor signify by saying aye.
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 Any opposition? Carried unanimously.
Now, we've made 2 amendments to the proposed motion. Do you want to take the motion as amended and approve it?
I think that's a good idea. We've got one amendment which we can vote on, and the other which simply puts our vote off until our next meeting.
For 6.
Right.
Yeah. So right now, the proposed motion, as amended by the board, we've modified 1, and we're delaying 6, keeping the existing provision in place until the board reconsiders 6. Otherwise, everything stays the same.
Except number 1, which was modified.
Right.
Yeah.
Is that clear for everyone?
Yes.
Any further discussion?
Motion and second.
Oh,
I'd move
Oh, we did
that
have
we
a motion.
adopt the motion on page 18 and 19 as amended as to number 1, and not addressing number 6, as we previously
Well, we've amended
decided.
number 6 to keep it in place until March. So it's as amended. There's number 1 and number 6 are amended.
Okay. That would be,
Is there a second?
Second,
Any further discussion? All in favor signify by saying
aye.
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 aye. Opposed? None, unanimous.
Okay. Did we have anybody else join us during that discussion? I wasn't sure if our called in. So, Mr. Chair, we would normally go on to item G, but since we don't have the individual who's raising the challenge present, would you like to move on to item H?
Item H, application of ethics code to poll workers. Page,
Mike Haas.
This is Mike Haas. Board members, please let me know if you cannot hear. I prepared the memo, although Mr. Becker may also want to chime in since it deals with ethics code issues as well. This memo starts on page 41 of the packet. We receive inquiries pretty much on an annual basis about whether election inspectors can work at a specific election when they may have a spouse or an immediate family member who is a candidate on the ballot. And traditionally, we have advised that there's nothing prohibiting that, although we have said it may not be a best practice just because of the perception that may arise. And we revisited this opinion in light of the recent Attorney General formal opinion that was issued to our agency regarding local canvass boards or various canvassing boards and the application of the open meetings law. And I think that opinion combined with some continuing inquiries caused us to revisit our prior opinion, and we have proposed a revised opinion for the board to consider, which takes a little bit more stronger position that election inspector should not act as a member of the local board of canvassers if that inspector has an immediate family member or spouse who is on the ballot or has a living arrangement with a candidate that could produce a financial benefit to the election inspector. And to refresh the board's memory, the local board of canvassers is comprised typically of the election inspectors who are at the polling place, but they are meeting after the polls close to process and count ballots. And that is the Attorney General opinion made a distinction between the inspectors acting in that capacity and their work during the day where they are doing individual administrative tasks and not canvassing ballots. And that's why we focused on the role of an election inspector when working as a member of the local board of canvassers. And so this does involve both the election laws. We evaluated it and concluded that election inspectors or members of the local board of canvass would qualify as a local public official, which then brings them under the purview of the ethics code for local public officials. And you could certainly theorize as to an opportunity that election inspectors may have in canvassing ballots may lead to a financial benefit for their immediate family member or spouse or themselves. And that's why we have taken this position or recommended this position. I think we recognize that it may, in communicating this to clerks, we are, of course, bumping up against the February primary where that will take place in the state. There may be an adjustment period. There may also be clerks that don't have much of an option depending on what other election inspectors are available. And in addition, we recognize in the memo that this is ultimately an interpretation and decision to be made by local district attorneys since they prosecute violations of the ethics code for local public officials. And so this is an advisory opinion that we would be giving to local clerks, but we wanted to make sure that this was vetted with the board and that the board had an opportunity to weigh in and decide whether this is the advice we should give.
This is Judge Byron. I have a question, but first a comment that I agree with your recommendations that we have to also avoid the appearance of impropriety of election inspector by reason of a relationship to a candidate. And I noticed that you have a language or has a living arrangement with the candidate. And we see more and more of living arrangements encompassed by that language. But doesn't that also require a statutory change? Because the statutory definition of a family member does not include a partner relationship or simply a living arrangement with another person, which happens so frequently today.
That's an excellent point and question, Judge Barlin, and it's one that we discussed, and Jonathan. And I think what we did, there may be a situation where the statutory language, has not caught up with current living arrangements, but what we focused on there was the potential financial benefit to the election inspector. So, for instance, I think an example that Jonathan has used is you may have a partner, you're not married, that partner is on the ballot, and you're working as an election inspector. You share household expenses, including rent or a mortgage, and the fact that that candidate may receive some income by winning an election may affect your finances personally. You may benefit from that personally, and so it's not a focus on the immediate family member, it's a focus on the election inspector's financial interests. Is that correct, Jonathan?
Well, I guess I'm raising the issue of the appearance as well. You're focusing on financial benefit, but an election inspector who is involved in the post-election canvass, and it's a very close vote. I think people could raise the issue of that election inspector exercising undue influence in certain close questions of whether a vote was one way or the other, an individual ballot. So I guess I'm raising a question as to whether we should also consider appearance as a issue for disqualification.
I think the only reason we stayed away from that a little bit is because the statute specifically says that a candidate cannot serve as an election inspector when they are on the ballot. And we thought if the legislature intended for there to be a prohibition on candidate spouses serving as election inspectors, that would be in the statutes, and it is not. And so we did not rely on that as a basis. We relied more on the angle of the ethics code.
This is Jonathan. Let me just add that the ethics code does not talk about appearances or the appearance of impropriety. That sort of concept is just not in these statutes, and it's a good concept, and judges are well aware of that concept, but it's not the basis of a statutory violation, for example. So we thought we should just avoid that in terms of giving advice.
It's just another point of clarification. The advice we have traditionally given is if you have an immediate family member or even not so immediate family member, you might want to not serve in that role as a poll worker just to avoid that appearance. That's been the advice, because we get this question every election, and primarily in the spring when there's many more offices up and many more local. It's not unusual in small towns for this to happen. And our advice does focus on, people are going to talk, here's the appearance, maybe for this election you should sit this out, but we leave that decision with them. But that's sort of the direction that we give, and we're modifying this to take a stronger stance in light of the ethics code issues that kick in, because in some circumstances these poll workers are now serving a role as a local public official.
Since the recommended action is based on the Attorney General's formal opinion, we limit ourselves to the language of the statute and the Attorney General's opinion, whatever it is, in anything formal that we take rather than to start adding on and embroidering to that?
The Attorney General opinion did not look at the issue under the Code of Ethics. That was strictly focused on the application of the open meetings law. And
what is the language that is used in the Attorney General's opinion?
the Attorney General opinion did not address whether an election inspector could serve when they have a spouse or immediate family member on the ballot. It only dealt with the open meetings law.
Here's the impact, this is Jonathan, the impact of the Attorney General's opinion is this. In determining who is a local public official, code, the definition is anyone who serves in appointed office unless the position is limited to the exercise of ministerial action. And what the
I
attorney...
remember now.
Yeah,
I
and what the...
remember now, Jonathan. So then we need to go to the language of the ethics.
Right, exactly. So now that we know that the ethics code for local officials applies to these election inspectors, that's why we get to the application of the ethics code, and I think we're applying that consistent with the way the board has applied it in the past.
And what is the language of the ethics code with respect to family members or persons living in certain arrangements? Is there any of that language there?
Family members, yeah, but living in certain arrangements, I don't see it.
No, that's not there, but what we have said is, but even if you're not married to someone, you have to look at two aspects. Is it a financial benefit to a member of your immediate family? And if there's no member of the immediate family, that doesn't apply. But you still have to look, is it a financial benefit to me? And if you're living with someone who helps pay your rent, then giving that person a job is a financial benefit to you, regardless of whether they happen to be a member of your immediate family. And this is just to...
Yes, but I mean, that's more nuanced, right? So that, I guess the bottom line is I would be in favor of tracking whatever language is in the ethics code, since that's, because of the Attorney General's opinion, we're bootstrapping onto the ethics code. The Attorney General's position leads us to conclude that the ethics code is applicable, and I would prefer just to stick with the language of the ethics code, including anything that pertains to financial benefits, but rather than starting to specify living arrangements or anything else that comes to mind, I would just feel more comfortable staying with what's in the code.
This is Jonathan. I would suggest then perhaps this change in the language where we say, consistent with the above analysis, the board advises that an election inspector should not act as a member of the local board of canvassers in the event that he or she is, I think that there should be that the candidate on the ballot of the inspector immediate family or the inspector would otherwise have a financial interest in the candidate's success or failure, something along those lines. Because then
Is there any other language in the Code of Ethics that would be applicable here?
The part of the memo on page 44, I think, quotes the relevant provisions of the Code of Ethics, and including the part saying no local public official may use their public position or office to obtain financial gain or anything of substantial value for the private benefit of himself or herself or his or her immediate family. And we can certainly simply, mimic that language. The difficulty and the challenge, I think, in our role in advising clerks is that we are trying to put the statutory language into practical terms that they can understand and apply without them needing to call us up with every specific situation. And I think that's what we attempted with the recommendation, was to put it in a little bit more of a plain language, interpreting, applying the statute to say exactly what it means, but simply in terms that could be more easily understood, that they need to pay attention to a candidate who they may not be married to, but whose success or failure could affect the inspector financially.
I think we run the risk of legislating in some additional language that isn't there. What Jonathan has says makes perfect common sense to me. I understand where you would like to go with this, but if the language isn't in the Code of Ethics, I don't see how we can require somebody who has a specific living arrangement with the candidate to comply with 1959 or make the official comply with 1959. If the legislature wants to include something about specific living arrangements, let them pass a statute on it.
But it's only an advisory opinion. And
Yeah, but-
you'd have to refer it to the DA, and the wouldn't necessarily have to prosecute if they didn't feel they're.
I should also point out that we do get inquiries from state public officials who say, can I take this action because I have a roommate who may be nothing more than a roommate or maybe a significant other who is going to, because of the action they take, benefit financially, meaning that the state public official is going to benefit from it. And this, I mean, and they're very specific when they ask these kind of questions. And our analysis has been, this does result in a financial benefit to you, and we advise you not to participate or be involved in this kind of activity. So it's not like, I mean, it's not a question of whether we're making new law. The law is there. You can't make a decision that has a financial impact on you. And if one of those is because you have a renter or someone else who's contributing to your expenses, who's going to get a benefit by a decision you make, that essentially gives you the same benefit. That's, and like I said, we've had these kind of questions come to the people we deal with directly, the state public officials.
I might be able to propose an idea here which makes sure that we are tracking the statutory language and puts less focus on the living arrangement language. We may be able to simply take out or has a living arrangement with and just substitute words like under circumstances in which the candidate's success or failure to win election would affect the inspector financially. Then it doesn't matter whether it's a living arrangement or any other circumstances. If the impact of the election results would be a financial benefit to the inspector, then we would say that inspectors should not serve on the local board of canvassers.
I would support that approach rather than putting in the living arrangement language, which is now found in the Code of Ethics.
I would second Elsa's motion.
This is Frankie. Are we proposing to take out any reference to living arrangement and just have it refer to success or failure to win financially affecting the inspector?
Yes.
You want to read that wording once more?
Wait, do you want me to or do you want?
Yeah,
I think that's a better way to go. There are also so many, once we start talking about living arrangements, there are so many living arrangements out there, right? I mean, that's something that I saw from the bench all the time. You know, people are kind of fluid sometimes. I'm not commenting on candidates, but, you know, there's a lot of stuff out there. And the bottom line is what constitutes a financial benefit, right?
Exactly. There's a whole range of relationships that the legislature perhaps should consider, whether they affect someone being an inspector or not. But the proposed recommendation as amended makes sense, and the rest is up to the legislature.
Mr. Haas will
The
read it again.
Okay, the recommended motion would be consistent with the above analysis. The board advises that an election inspector should not act as a member of the local board of canvassers in the event that he or she is a spouse or immediate family member of a candidate on the ballot, or under circumstances in which the candidate's success or failure to win election would affect the inspector financially. I guess it should read, in which a candidate's success or failure to win election would affect the inspector financially.
Any further comments?
That consistent with what you'd like, Judge Lemalis and Judge Nickel?
It is with me.
Fine by me.
Okay, we have a motion and a second. No further discussion. All those in favor signify by saying aye.
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 No opposition, unanimous authority.
So did we get another participant to our meeting?
Mr. Bugenhagen?
Yes, I'm here.
Okay. We had put off agenda item G, which is the ballot access report, to take action on this, and we understand, Mr. Bugenhagen, you have filed a challenge to one of the candidates. We have someone present on the candidate's behalf, so perhaps, Mr. Haas, you could set the stage for the board, and we will hear from Mr. Bugenhagen, and then we'll hear from Judge Vandewater's representative.
Okay, so this involves the materials which I emailed out last night. There was an additional memo that the challenger submitted this morning that I also emailed out to board members, and which he can cover. But we have one ballot access challenge for the spring election involving Judge Linda Vandewater, the current incumbent Waukesha County Circuit Court judge. Mr. Paul Bugenhagen has filed a challenge to those nomination papers, and I tried to set out in the memo the basis for the challenge, which really goes to the format of the nomination papers and not to any signatures. We included the copies of several nomination paper samples. I think it's easiest to really explain what we're talking about here by looking at those. A little bit more difficult to explain in the text about exactly what we're dealing with, but the challenge has to do with the use of the title judge on the paper which contains the nomination form. So what that do is have the challenger make a presentation. We have a representative of Judge Vandewater's campaign here to respond, and then I can briefly review our recommendation and answer any questions, and then the board can take action.
Okay. Let's have the first appearance.
Mr.
Okay,
Bugenhagen?
this is Attorney Paul Bugenhagen. I'm a candidate for the Waukesha County Circuit Court Judge Branch 10, and that's Judge Linda Vandewater is the current holder of that position. Now, I'm challenging her nomination papers under the statute 8.102B, which is laid out on the memorandum that was provided to you, and starting with the very first line in there, that the words that are printed in italics on your memo are supposed to substantially appear printed at the top of the nomination paper. In there, in bold, that was emphasis added by Mr. Haas, I believe, there's no other abbreviations or titles. So that's the part that we're looking at here. Now, the judges and attorneys, obviously, we're used to looking at to ascertain and give effect to the true intent of the legislators in determining what that statute means. In this case, Judge Vandewater herself, if you will look at the attachments to the memo, Exhibit D2 admits that the judge is illegal. It's right in the email. It says they are now printed, but Judge Vandewater is telling me they're illegal, saying re-elect judge. Please confirm. Viola Hamelman sent to the GAB Exhibit D2 at the bottom of the page. So Judge Vandewater herself was under the understanding that it was illegal to use the word or the title judge on the top of her nomination papers. Now, why is this statute here? What's the intent of this? Other jurisdictions, state of Illinois, for instance, the case that I cited in my memo, the Rita versus all was Maiden and everybody else in that case, uses the line that the statutes, they have a similar statute. Statutes prohibit the use of titles on a candidate's nomination petition because its title might induce a voter to sign that petition on the strength of the title, not being familiar with the candidate's abilities, but simply based off of the status of that title, whether it's a doctor, whether it's a judge, whether it's a coach, whether it's a reverend. So that's the first intent, I believe, of that statute. The second one may be what the board was just considering, Section 19.59 of the Wisconsin statute, that elected officials are not supposed to use their titles in order to influence or to obtain benefits. The statute clearly states that no titles are supposed to be used. Using a title of judge will prompt someone or may induce someone to sign that nomination paper. Now, it's not logical to accept the GAB's argument, or the staff's argument, or obviously what is now, I believe, Judge Vandewater's argument, that you can put a title anywhere else on that page. It wouldn't be logical that if you put in that box just his name, Linda Vandewater, right above it, put in big bold letters or big bold words, Judge Linda Vandewater, we don't know what we're actually referring to when the statute reads, or when her nomination paper reads, highly undersigned, request of the candidate whose name and address are listed above. That's just the first line of the statute that Judge Vandewater has on her nomination papers. So what we're referring to is the candidate named above. Now, are we looking at the name in the box, or are we looking at the name up higher, Judge Vandewater, and it appears twice at the top of her nomination paper. So Judge Vandewater knew that she was not following the statute, and I believe the staff is not following the statute, that they're allowing, the recommendation from the memo is that it's close enough. Well, it's not close enough. The intent of the statute is to keep people from being influenced by titles. The staff memo that the name appears in the box makes this okay does not make sense either. They state, well, the statutory language that's required refers to the name up above. Now, it doesn't say which name up above we're referring to, and it's not a duty of the board here to determine, well, which name was the elector referring to? Was the elector referring to Judge Linda Vandewater that was placed up higher, or was the elector referring to the name in the box? The box that's listed on Judge Vandewater's nomination paper clearly states no titles may be used. Now, the staff also addressed opinion of Judge Micey, I believe is the name, M-Y-S-E, from 2010, in which there was discussion on a similar issue in which Judge Vandewater was actually on the other side of this, that Judge Riley was the one that offended this statute in 2010. Now, no challenge was made to his nomination papers because Judge Vandewater did not know about it in time, but Judge Micey had stated that if a challenge was made, that the board would likely have to reject the nomination papers of Judge Riley. Now, the staff had written that part of that reasoning was that to be falsely identifying himself or herself and misleading voters. Now, that very well may be, but the purpose of this statute is not to guarantee that somebody is not misrepresenting themselves, because otherwise that box would say no titles unless you're a candidate, or excuse me, unless you're already a judge. Then you could put Judge Linda Vandewater. It strictly states no titles. There's no exception. You can't put it in if you're a judge. You can't put it in if you're governor. It simply states no titles. I also provided on my memo how other states have handled this. I've printed in there the case of Rita versus Maiden from Illinois, which addresses this very question. It's exactly on point. The difference is I believe the Illinois statute might be even a little bit clearer than Wisconsin statute, but the reasoning behind them is the same. For the staff to take the position that they're taking would create this situation in which it doesn't matter that the statute says no titles. You can simply put it somewhere else. Why would we have a statute that says no titles if you're allowed to put it somewhere else? Finally, I'm asking the court, or the board, to reject the nomination papers of Linda Vandewater. Yes, it's a drastic. However, her own admission is that this is illegal. She knew about this on December 1st when that email was sent to the GAB. She knew that these nomination papers were illegal. She interpreted the statute the correct way, giving effect to the intent of the legislators in that no title ever were to be used on the nomination papers. So I'm asking the board to review this and reject the nomination papers of Judge Vandewater. Thank you.
Any questions by any members of the board? Hearing none, thank you for your testimony. We'll move on.
Thank you.
I believe we have a representative on Judge Vandewater's campaign.
Vi Hamelman. I just want to make sure the microphone is there. Okay.
Thank you.
Want to make sure we can hear you.
Good afternoon. I am Vi Hamelman. My full name is Viola Hamelman. And I want to clarify first that Judge Vandewater had not seen a physical copy of her drafted nomination papers. I just want to say she heard me use the word judge when I was discussing what they said and was concerned about the word judge, and therefore I sent them to a second person here at the GAB. I have been doing this kind of work on and off since 1986. I have never been questioned. I have never been questioned about my desire to stay within the framework of the law. I choose to stay within the framework of the law. I like living free. So, we'll go to the GAB Rule 2.057, which allows for campaign advertising. One of the things that is not clear in the photocopied versions of the papers that you have is that Judge Vandewater's nomination papers were in color. And at the very top of the corner of the piece of the paper, it was very clear that it was in red and blue. It was very much in color. Underneath that, about a quarter of the way down, it said nomination paper for nonpartisan office, all in black, and it is a formal looking form. It makes it very clear that the top here is under the guise of campaign advertising, and this piece here is a form. Would anyone like to ask any questions?
of this witness?
Do you have?
May I make just one brief response to that? This is Paul Bugenhagen.
I've got a question first, if you don't mind.
Yes.
Have you read the response by staff to the complaint?
Yes.
Any comments that you want to make on that?
I thought Michael did a great job.
Way to go. I finished with my question.
Go ahead with your response.
Regulations, but they are superseded by our statute, as we know. So that may be the process of how things are handled, but 2. And put a slogan on a nomination paper, but that does not trump the statutory language in 8.102B, which states no titles. Thank you.
I have a question, Mr. Bugenhagen.
Yes.
I understand what you're saying. I certainly don't like this kind of nomination paper. I think I've seen it before. And the issue, though, has to do with the Wisconsin statute. I'm looking for the Illinois case that you cited to us to see what the language is in that. But do you have any authority for the proposition that the Wisconsin legislature intended this statement about no other abbreviations or titles to apply to the entire document that contains the nomination paper, or whether nomination paper begins where the title nomination paper appears on the document.
I think what would be most telling on this, the statute right in front of me, but the rules of our nomination papers allows for corrections when it comes to the signatures or the electors signing. It doesn't allow for the correction of the headings of the candidate. It doesn't allow for them to change what's on top. Once those are circulated, that's finalized. It is the candidate's duty to follow the law. Judge Vandewater admitted that this is illegal. She was in the same situation in 2010 on the other side when she stated in a debate that Judge Riley had done this wrong. Now, the statute stating that there's no ability, I believe it shows us the seriousness of that is portrayed. And if you the Illinois court decision that I referred to, Rita versus Maiden, and I printed the excerpt, copied and printed the excerpt on my memo, states that yes, it is a drastic proposition to strike someone from the ballot. However, that the nomination process is the beginning of our election process. To allow someone to simply change or correct or take off that judge would allow people to circulate nomination papers illegally and then simply change it later, take off the judge or whatever title that is, and be able to continue on. So, drastic solution here. But I believe that the statutes and stating that the headings of these cannot be corrected is very indicative of the seriousness. Thing on that nomination paper should let the elector know what this is about, not some advertising on the top of it. This is about nomination papers, not advertising. So the rules in 2.057, yes, those are regulatory, but they cannot supersede the statute that says this has to appear substantially at the top of the page and states no titles. Thank you.
Mr. Bugenhagen, this is Judge Vokey. Twice now, at least, you've alluded to the fact that Judge Vandewater has admitted that she's done something illegal. Is that admission anywhere in your materials?
That is actually in the memo that you received from Mr. Haas. It is the exhibit, I have the number here, D2. If you flip D2, at the bottom, there is an email from Viola Hamelman to Richard, is it Bohringer, Bohringer. At the very bottom, it states, I'll just read it. Richard, I sent this to Jennifer Webb, and she approved. They are now printed, but Judge Vandewater is telling me they are illegal, saying re-elect judge, period. Please confirm. As I said, they are now printed.
I don't see anything in there that's an admission of wrongdoing, Mr. Bugenhagen. I think basically it comes out as a request for people to check on something that she wants to be confirmed. So I think you're kind of overstating it.
Her impression is that
Just
they're
a
illegal,
minute.
so she wants to.
We're not going to have a continuing
see
discussion.
what their opinion is.
We're going to bring this to an end. You have your final say, Mr. Bugenhagen.
Thank you. The intent of the statute is clear. It would make no sense to allow titles to appear plastered all over a nomination paper and ignore the fact that 8.102B states no titles. The fact that it appears in one little box way does not clear the candidate of wrongdoing when they put a title somewhere else on the page in which a elector could refer to when deciding whether or not to vote for or to sign the nomination papers of that candidate. Thank you.
One more comment from the other side?
I would just say she had not seen a hard copy. I was reading it to her, and the really remarkable difference is that Judge Riley's at the very top of the piece of paper nomination paper for nonpartisan office, whereas hers clearly has it a quarter of the way down after the part where we refer to as campaign advertising. And in the box where her name does go, it is in very bold letters without any kind of title.
Thank you both for your testimony. We'll now proceed to board discussion of the request. And Mr. Haas, your
So,
comments.
Just briefly to recap what's in the memo, and I did neglect to cite the administrative rule that's been discussed here, section 2.05, subsection 7, and I'll briefly read it. It says, the filing officer shall accept nomination papers which contain biographical data or campaign advertising. Goes on to say that the normal disclaimer statement is not required on any nomination paper, which is not an issue here. So just a few points. As a memo point notes, staff believes that the Vandewater nomination papers are in substantial compliance. The statute requires substantial compliance specifically of that statement which the electors are asked to sign. And that's done in two different ways, which I think is why it is instructive to look at the samples. The Vandewater nomination paper tracks the nomination paper which has been published and approved and is on the GAB website. That has the boxes where you fill in the candidate's name and address and position they're seeking. The nomination paper from Judge Riley, which was the subject of the 2010 discussion, you can see Judge Riley, within the statement that was to be reviewed and signed by the electors, within that statement he indicated Judge Paul Riley. And that's why I thought it was illustrative to look at that because it's a different way of incorporating the name into the statement that the elector is asked to sign. 8.1, section 8.10 only governs, it doesn't govern anything else that is on the form. That has been the view and application of the law that the staff has always taken. In addition to the case, the nomination papers were pre-approved by our staff not once but twice, and the second time was after Judge Vandewater raised this as an issue and sought clarification. I would agree with Judge Volke that email, in staff's opinion, is not an admission or conclusion that these nomination papers were invalid. I would also note that there is not an issue here of the nomination paper being changed. There is some reference to that. The heading was not changed. The nomination papers that you see are the nomination papers that were distributed to the electors. I would also note that there's also a statement that staff's position is that these nomination papers are close enough, and that's not at all. Our position is that the administrative rule is applied consistent with the statutes, that they are applied together. The administrative rule allows biographical or campaign information to be on nomination papers. The statute requires that statement signed by the electors has to be substantially in compliance with the statement in the statutes. And finally, I would just note that for the board to invalidate these nomination papers would be a significant departure in the staff's application of the law. There are commonly candidates from governor down to local candidates who put their title on the nomination paper outside of the statement that is being reviewed or that is being by electors, and our staff has always approved those nomination papers. Their candidates have not been on notice that the board was going to take a different view of that provision. And so those are the reasons, I think, because we think it's in substantial compliance. The candidate relied on 2 staff members of the GAB to pre-approve the forms, and that this has been the application of the law, and I think it is consistent with both the law and the administrative rule, and those are the reasons for our recommendation that the complaint should be dismissed.
Questions or further discussion from board members?
I move that we deny the challenge.
I'll second it.
Any discussion on the?
Just Roland, I have a factual question. I don't have that nomination paper in front of me, but am I to understand that the top part of the paper on which the nominating petition appears, the so-called advertising, political advertising section is in red, and the title judge is in red, and the rest that applies to the nominating petition is black?
It's in red and blue with a colored or photograph of the candidate.
Okay, thank you.
You're welcome.
And the balance is in black.
And the balance is in black.
Thank you.
Any other comments? Are you ready for a vote?
Probably the roll call, right?
Yes. We'll have a roll call vote on this. Call the roll.
Judge Barlin?
Aye.
Judge Frankie?
Aye.
Judge Lemalis?
Aye.
Judge Nickel?
Aye.
Judge Vokey?
Aye.
Judge Freilich?
Aye.
Motion carries. Challenge is denied. Thank you very much.
Always a pleasure.
Then we will move on to the rest of the report here. Mike and Diane.
Lead election specialist Diane Lowe is going to present the memo regarding the remainder of the ballot access issues and certification.
Is that Mike talking? A little louder, please.
Okay, it was, but Diane Lowe is going to take over the presentation now.
Good afternoon. Okay. The offices for which candidates are seeking to be placed on the ballot are Supreme Court, Court of Appeals, Districts 1 and 3, various circuit courts throughout the state, and then, of course, the special election in Senate 20. That office was vacated by Senator Grothman. Circulation began December 1st for the judicial offices, December 16th for the special election, which was in the order of the governor, that would begin on December 16th. Regardless of the office, all papers were due on Tuesday, January 6th at 5 p.m. There were a total of 101 candidates that registered for the various offices, 94 nomination paper sets submitted, 7 registered candidates didn't file any papers. As far as when papers were received, as usual, most of the papers, I believe 61, were received in the 2 weeks of Christmas and New Year's, and those were all 3-day weeks, so those were quite busy for staff. Just as one point I wanted to make, there were 5 candidates who submitted papers and were sufficient, but they were within our policy cutoff of 10% over the minimum. Whenever they're less than 10% over the minimum, our policy is to contact that candidate and just tell them that they're squeaking it a little bit and that they might wish to, if there's time, bring in more signatures or try to rehabilitate signatures that were struck. Did that. I don't know if any of them did that, but anyway, we did let them know that they were close, and they were all in contested elections, also contested offices. All incumbents that decided not to run for office did file a notification of non-candidacy, so that prevented us from having an extension of the filing deadline. I have noted on page 22 some irregularities that we've run across, and a lot of these are typical irregularities in the format of nomination papers that do not affect ballot status, or at least that staff has decided don't affect ballot status. The first one has to do with the office title. There's always some variation. Of course, for example, circuit court judge, we'd like to have it say circuit court judge, branch, whatever, or circuit court judge. We get things like county judge, judge, and then somewhere else on the paper you'll see that they refer to circuit court judge. This is a common irregularity. We don't feel it is misleading. People knew what they were signing, so staff did not strike those signatures. Even if we did, there were enough, they wouldn't have struck enough signatures to make them insufficient. 2 and 3 have to do with election dates, the date of the election at the top of the paper. There were 2 candidates that had this issue. The first one, a candidate for Sheboygan County Circuit Court Judge. There were only 4 of her papers that had the incorrect election date. They used 2014 rather than 2015. The rest of her papers were fine. Even if we had struck those, she still would have been sufficient with 372 signatures. Staff believed that, regarding her in the election date, it was clear that she was running for an office at 15. Michael Gage, on the other hand, candidate for Outagamie Circuit Court Branch 5, did this on all of his papers. They all said April 7th, 2014. Again, we have decided that, and I believe that the former elections board, if not the Government Accountability Board, has decided also that this is not confusing to voters, that they knew they wouldn't be signing a paper for an election that occurred in the past. All of his papers, he was not opposed. There was no challenge to his nomination papers. Number 4 had to do with circulator errors. These 2 we run into frequently. It's the case of either 2 different circulation dates, dates on the certification of circulator by one circulator. Sometimes they feel that if they've done them on 2 different days, they need to date them when they complete the first 5 and complete it again when they complete the next 5. Regardless, there was a date on there that was on or after the latest date of a signature. The second one was kind of the inverse of that. There were 2, each circulator indicated the signatures that they were responsible for. So it was filled out, it was irregular, but it was filled out sufficiently. Even if we would have struck those signatures, it would not have affected the sufficiency of the papers. Number 5 was an issue of information on the paper being cut off. Usually this happens when they have added another column for contact information of a signer, and then they cut it off before they bring it to us, and some of the information was cut off. We did strike the signatures that were on those pages, but as you can see on the top of page 3, there were very few pages that we struck, and all 3 would have had sufficient signatures anyway. And finally, number 6, there were a number of candidates who filed papers that did have the signature of elector column, but the signature of elector appeared, at least to our non-handwriting expert eyes, to be written by the same person. None of these would have affected the validity or the sufficiency of the papers, but there were, as you can see, a number of them that looked like they were written by the same person. I think perhaps that circulators are not aware that the signer is the one printing the name, and if the signer didn't print the name, this is just my assumption, is that then the circulator decided, well, I'll just write it in.
But Diane, I noticed this only happened in Milwaukee County.
Those are the only ones that we noticed, yes. And you're right.
Diane, you're speaking about, as you can see, I'm looking through my materials, and I don't know if those were provided and somehow I'm missing them.
On page
or...
23, 22 and 23.
I see the summary there. Oh, I'm sorry. I thought you were referring to that to the actual circulated, the actual nomination papers in front of me. I thought maybe you were saying that we had gotten the materials with the printed names.
Oh, I'm sorry. No, this was just the
summary.
the fact that the signers signed their names, and then it looked like someone else had printed their name and printed another of other names beside those signatures.
Those aren't attached.
No,
Those are not.
they are not. No, they are not attached to the report. There were, the next section on page 23 is the candidates for whom staff recommends denial of ballot status. And I have listed 4 here, and I will call your attention to the very first one, this Jesse Leixenring, who is a candidate for Adams County. He's required to turn in 200 signatures. He did submit 200 or maybe a few more, but after we went through them, some were struck due to technical errors, and he was down to 192. That therefore, on the candidates registered printout that you have, he is listed as to be denied ballot status. After his attention was called to the insufficiency, he did repair those signatures by affidavit of circulator, and he submitted those on Thursday the 8th, which was within the time frame of rehabilitating those signatures. He said he did this by fax, I believe, fax or email, electronically anyway. And we apply the fax rule to that, meaning that if we receive an electronic transmission of that affidavit correcting those signatures, and the original is received, postmarked no later than the date of when they were due, which would have been Friday, we count those signatures. It's considered received the date of the fax or the email. So he did repair exactly 8, which brought him up to 200. So he will now be listed as approved rather than denied. The other 3 there did not rehabilitate. The Michelle Greendeer from Jackson County simply used the wrong form that did not have a printed name column. We did count 53 signatures because some of the signers did just happen to also print their name above their signature, but of course she hasn't enough to get on the ballot. And this Fred Utek, who was a candidate for State Senate 20, and I believe he probably did, I didn't check for sure, but his issue was that on the top of his nomination papers, where it's asked the candidate to write down their municipality for voting purposes, we noticed that he had a different municipality for voting purposes on quite a few different pages. He listed Port Washington, he listed West Bend, he listed the village or the town of Belgium. So when questioned, he said he thought it referred to the municipality in which he was circulating that page. So not what was required. So he was down to 287, and he did not repair any signatures. The rest of the...
I'm sorry.
Go ahead. That's okay. That's all right.
I'm sorry.
The rest of the people, the rest of the 7 listed here just simply did not submit nomination paper. So under probable primaries, we are going to have a primary in the offices of Circuit Court Judge in Jackson, La Crosse, Lafayette, and Sheboygan counties, and then, of course, for the State Senate District 20. Mike has already discussed the one challenge, and the board has dismissed that challenge. So I guess that brings us to the recommended motion, which now has to change a little bit due to Mr. Leixenring rehabilitating some of his signatures and now becoming sufficient. So the recommended motion would be to certify ballots for the 92 candidates that will be listed as approved. The pending was pending the submission of statements of economic interest. All candidates have done that. But to deny ballot status to 9 candidates listed as denied.
Is there a motion?
Before we do that, I just wanted to state, with respect to the candidate, the Milwaukee, the duly noted Milwaukee candidate with the signatures that appear to have been filled in by one person, I'm relieved to see that it did not affect ballot status. And I think that this furnishes us with an opportunity to alert those candidates to the appearance in some way, because this is a statutory requirement that the signer prints his or her name. We've had a number of discussions about this, and I think we should not miss the opportunity to let them know, let these people know that while it did not affect their ability to get on the ballot, and no final determination was made as to whether one person printed all of the names, that this is what it appeared to us to have happened, and that the statute requires that the signer print. And I think that should be incorporated in the motion, or I could make a separate motion to that, but I don't think we should simply ignore it because it does not affect ballot access. If nothing else, everybody in Milwaukee will, and that will help them not do this, because if staff noted this with about 25 pages, it had to have happened. I mean, I didn't see the pages, but I don't think we should ignore this.
So your motion is what?
For staff to write to these candidates and say that the statute requires that the signer printer his or her name, and that with respect to their signatures, there were some pages that appeared questionable. I don't know what's the most delicate way to put it, and that even if those pages had not been counted, they still had plenty of signatures to get on the ballot, but to remind them of the statutory requirement that the signer print his or her name. And, you know, Judge Witkoliak had 10 pages like that, presumably. Judge Brostrom, 9. I know Judge Hancher, he's a dear 3. He'll tell everybody when he gets that letter, assuming that we do send out that letter.
You got a motion?
I'll move the recommended motion at the bottom of page 24.
Well, Judge Lamelas has already made a motion. The question is
Something else.
on
No.
something else.
We have to, is there a second to Judge Lemenis' motion? To send a letter to the candidates that didn't file nomination papers that appeared to have the signers also print the name.
Second.
We have a motion and a second. Any further discussion on that issue? All in favor, signify by saying aye.
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 Opposed?
No.
We had a roll call, clarify it.
Judge Volkey,
No.
Judge Nickel,
Aye.
Judge Frankie, Judge Frankie, Judge Lamelas,
Sorry, I had to turn the mute button off. This is Frankie. I vote aye.
okay, gotcha. Judge Barlin,
Aye.
Judge Freilich,
Aye.
motion carries.
Then I'll make my motion again, as to the recommended motion on the bottom of page 24 on ballot access.
I'll second it.
I'll second it.
We're giving it to Judge Volkey, Judge Lamelas.
I'm sorry?
We're-
You're giving it to Judge Volkey? Okay.
Yeah.
He beat you by.
Oh, that's only because he's there.
Right.
And
We have
that,
you on a 3-second delay, we're way ahead of you.
and that motion would incorporate the Leischner, or whatever his name is, did have valid access, 9 that were disqualified.
Any further discussion? If not, call roll.
Judge Nickel,
Aye.
Judge Voki,
Aye.
Judge Barlin,
Aye.
Judge Frankie,
Aye.
Judge Lemalis,
Aye.
Judge Freilich.
Aye.
Motion carries.
If I could, Judge, I just wanted to take a second to thank Diane and her, as well as our other division staff who completed this process of reviewing nomination papers. As her memo indicates, a number of the candidates had thousands of signatures which needed to be reviewed. Certainly is not as intensive as the nomination paper review for fall candidates, but we still have a short time window, and candidates tend to wait until the last week or last few days to submit them. And this all occurs largely over the holiday weeks, where we have 4 state holidays, and staff is trying to squeeze in vacation that they're required to use. And so our staff really cooperated to make sure we had coverage to assist candidates when they came in, and to make sure that the nomination papers were reviewed in a timely manner. So I just wanted to acknowledge that and say thank you.
It sounds like a very difficult Christmas holiday, and it probably is like this every single year.
It is.
We still have substantial discussion ahead. I think it's maybe time for a 10-minute break.
Okay, we're going to take a 10-minute break.
That sounds great. We have reached a hotel. I'm freezing in the parking lot, and so I'll go inside.
Okay,
And,
are you going to stay connected on your phone, or are you going to dial back in?
I'm going to dial back in if that's okay, since I
It should
probably
work.
have to watch it.
I'm going to stay online.
Okay.
Is that okay,
Yeah,
Kevin?
that should work. It's only when we disconnect that you lose your.
Okay, all right. Thank you. I'll call right back.
I've been here all along.
I am Elsa Lamela.
How about you, Judge Frankie?
Judge Frankie, are you on the phone? Still waiting for Judge Frankie?
So, Mr. Chair, we're up to item I, which is on page 46, which is Mr. Haas.
Mr. Haas, what's the goal of your detailed explanation? Okay, I think the presentation part of this will be brief, but the materials do start on page 46, and we have a set of documents for the board's review or information. Every year, on an annual basis, we are required to report to the U.S. Election Assistance Commission on the use of our federal funds, our Help America Vote Act funds, and what types of activities we have used those funds for in the calendar year. There are two different funds, the HAVA 101 fund and the HAVA 251 fund. They have some overlap and some separation as to what they can be used for. So you'll see that those two reports, most of it covers the same territory, but those reports were submitted at the end of December to the USEAC, and that focuses on activities conducted by our staff that is federally funded. And then behind that, we included a report for the board, a list of major achievements in the elections division for the past year, and this is something that we have done for the past 4 or 5 years. We typically post it on our website, communicate it to clerks. Of course, a lot of it cannot be done without the clerk's help and cooperation. And almost everything in all of those reports should not really be new to the board. It should be some familiar matters there, or at least ring a bell, because we try to make sure that if it's not covered as an agenda item at the board, that those types of activities are at least covered in our division updates at each meeting. So it's not necessarily, although even as somebody who's involved in most of those tasks or managing them, it is always a little bit surprising and really impressive to see what's been done over the past calendar year. And last year was a busy year, a lot going on, and you tend to forget unless you see it all in black and white. And a lot of those projects, interact. The same staff is working on them, and I think it's just an enormous amount of work that's been accomplished. I think it's a credit to our staff, and we wanted to share that with the board. It also comes in handy, not only to educate the public and the board, but when we get questions, for instance, from the Legislative Audit Bureau, about staff activities. This gives us a good summary, and as I noted in the memo, many of these tasks which take our staff, days, weeks, and months, were not subjects of the Legislative Audit Bureau at all, and we wanted to make sure that they were recognized. So there's no action required, but we wanted to make sure we shared those.
I'm looking at page 54. Commission, in the middle of the page, there's a paragraph, the commission made 19 recommendations. 16 of the recommendations were items for states to consider. 6 would require legislative changes. 3 could be done administratively. Have we taken a look as a board of those recommendations?
We made a presentation to the board about the Presidential Commission recommendations after that report was issued.
Excuse me, I'm back. I thought I was connected, but apparently I wasn't. Had to reconnect.
Item number
Aye.
5.
Just briefly covered the fact that we had submitted reports to government, in addition have about the activities of our federally funded staff, and then have a list of what our elections division has accomplished over the past year. Judge Freilich was asking about an item on page 54, which related to the report of the Presidential Commission on Election Administration, and I was indicating that we had brought that commission report to the board. I think it may have been at our March meeting, sometime early in the year, reviewed the recommendations, and our summary here indicates a number that would require legislative changes and some that could be implemented without legislation. We have not come back to the board, after that with a review of any changes that we're making administratively or implementing any new procedures as a result of those recommendations.
Did we recall that? Did we approve of staff supporting those legislative changes and conveying that to the legislature?
Well, I can look exactly what a recommendation was. My recollection was it was essentially a report for the board's information to say this is what this commission is recommending, and we identified things that could be implemented, could be changed, but I don't think that we asked the board for
90, it starts on page 90 in a formal way at the hearing tomorrow.
Now that you raised that, I think that will be one, I think we will add that as one of the appendices to what we're providing. In addition to my written testimony, they will get appendices, as Mike mentioned, that have our list of accomplishments. We're them, and the board mentioned this as well, the list of statutory responsibilities of the agency. We plan to share Judge Barlin's recent editorial on the felon audit process with the committee members as well, and I think it would be good to include this chart.
Is there an explanation for why some of the entries are shaded in gray?
To separate the types, if you look at them, they're all related. In other words, in their audit report, they usually had 2 recommendations, such as the very first one, promulgate these rules, report to the committee on its status. Sometimes they might have 3 recommendations at once. And so they were all shaded to keep the ones that were combined in the audit report. In most cases, there's only 2, and the second one is to report, but then to move on to the next area. That's why the shading was done. It made it easier, we thought, for the reader to see related recommendations.
Got it.
John, it's related to the ballot litigation earlier this year.
You know what? I was going to refrain from talking about the benefits of shading, Judge.
I was going to suggest there be a double line between the gray shading and the white shading.
I recall that you were a line kind of guy, or were you a line opponent? I can't remember, but I know you were out of the fold a couple of meetings ago.
I'm the line type of guy, he's anti-line.
But apparently he favors double lines. Any questions about the audit recommendations from board members?
I've got items on 52, 54, 62, and 63 refer to a penalty schedule. And the answer is they're now all used in current practice.
Right.
When we meet in March, can we have a copy of those schedules?
Yes, and we'll actually send you a copy before March, so you have it, but we'll make sure that you have it.
Thank you.
That was something we had discussed.
Any other comments or questions? If not, we'll move on to the next.
This is the proposed legislative agenda, which had 2 board subcommittees. Oh, I'm sorry. Item K is request for approval of administrative rule scope statements. Nate, could you handle that,
Ken, sure.
since I made you do the work for me?
Well, I wrote the memo.
Okay, Mike's gonna.
I will keep it brief. I know we have a lot to get through yet. If you have specific questions, please let me know. But as you know, the LAB audit found, the administrative rulemaking the board to be a little lacking, and we wanted to get this rolling as soon as possible. So the first giant step in in the rulemaking process, as you know, is to submit statements on various topic areas to the governor for approval. Based on the LAB report, 95 and 96, the ones that they specifically identified are laid out there. And we wanted to, at least discuss some of these or get feedback from board members if they have any specific thoughts, but to at least get the ball rolling on drafting the scope statements on these areas and get them to the governor. I provided some of the rules too, they're in various stages. We've, as for example, the observer rule, we spent a tremendous amount of time. That House went through the entire process. Unfortunately, we're going to have to start over on that one as the legislature take it up, and that time has expired. But examples like that where we have a lot of the work done already. I tried to provide some of the examples, some of the attachments of what the scope statements, would look like or have looked like in the past on some of these rules. Obviously, the board will have time to weigh in specifically on how the rule will look. But as far as the scope, most of the stuff is pretty straightforward as to the subject area that needs to be addressed. It is basically written right in the statute. The board shall promulgate rules in this area, and that will be reflected in the scope. The scope statements that will be drafted and submitted. So, if you have specific questions, you can. I'm willing to answer those questions. Kevin may have a little more to add as well.
Just that the recommended action is on page 97 for the board to direct staff to take certain steps with respect to the rules as they are laid out.
And the reason for the kind of the separate recommendations, that was just in an attempt, if you had specific feelings about certain ones that you wanted us to move forward on, that's what the attempt was. Section 8, paragraphs 1 through 6, those are kind of the statutory mandatory ones that the LAB identified. Section 8, paragraph 7, that's dealing with the settlement offer schedule that Judge Freilich just mentioned. The statute there is actually the board may, by rule, prescribe categories, so that's kind of a decision point. Many discussions have been, whether we want to do that by rule. It was back in 2008. It was kind of done, by board resolution. This is what the schedule is going to be. They adopted it. The rule was never formally adopted. But that's why that one is separated out from the other one, because that is the board may, whereas the other ones are the board, the board shall promulgate. Number 3, section B, those are 2 that the scope statements have already been submitted to the governor, and we just are looking for, continued assurances that the board wants us to continue, pursue those rules. And then number 4 is just to look at the process for repealing some of the administrative rules that are out there that were not approved by the board that are still on the books. It's also identified by the LAB audit as well. So that's the reason for the 4 separate recommendations.
I had a question about 4.
Sure.
I was having trouble understanding the idea of repealing rules that were not adopted. Does the staff agree that these rules were never adopted?
Yeah, basically, when the GAB was created, we were required to review every administrative rule and every opinion of the former 2 boards. And if we chose not to adopt those rules or opinions, then they dropped out. And so there were 8 rules that the board decided for reasons that they just didn't or didn't make sense anymore not to adopt. And the formal repeal of those rules never went forward. So that's why they're in that particular category. What we're not clear on, since there's been so many changes to the administrative rule process, is whether we need a scope statement to do the repeal process. That's why the directive is that, and I'm not quite sure it's to promulgate rules, it's to take steps to repeal administrative rules identified.
Why are we repealing?
It's a technical question. We don't need to decide it today, but if these have been effectively repealed or in some way not adopted, then they're really not rules that need to be repealed. There may need to be some mechanism to get them off the books, as that phrase was used.
And that's really, the recommendation should be the board directs staff to take steps to improve the administrative rules identified by the LAB, because they are ones that the original board, when going through a process that lasted about 15 months, the board said, this is not a rule that we are going to reaffirm. That was the choices that they were given. So the board had a very workmanlike task in front of it for all of 2008 and into 2009 on this process.
If they weren't adopted, how could they be repealed?
I think the administrative code provisions require that they actually be removed. And one of the questions that is unanswered was, how do we remove them? I mean, they already existed in the code at the time that the GAB was created. And then the question was, if the board does not reaffirm them, then they go off the books. And it may be that we can work as we did when we created the various sections, that we can do this without any formal process, that the Legislative Reference Bureau, which now handles administrative rules, we can point to the provisions of 2007 Act 1 and say, because the board chose not to reaffirm this, it should simply be removed from the code, as opposed to us drafting a scope statement, having the governor approve it, have the board review it, adopt a rule-like process that says we are now repealing GAB X ... And that's what's not clear.
Why did they get into in the first place if they weren't adopted by this board?
Well, that's one of the issues with the Legislative Reference Bureau and our follow-up with them, because one of the steps we had to take initially was to create a new code and renumber all of the rules, because you to a new code provision called GAB on this. And then at the time that was done, the board hadn't gone through and reviewed all of the steps. And simple, under 2007 Act, Reference Bureau may say, since the board chose not to adopt this,
Scissors, I'll cut and paste and they'll be gone.
I'd like to think that's the way that this will proceed. I'd hate to think we need a scope statement and approvals and running it through a committee to do.
A physical removal from the books.
Yes, right.
But that's why they're in a separate category.
My memory being here when all that was done and accomplished was that those that were not adopted would just not be in effect.
During that time, though, there was changes in the custodians of the rules that went from the reviser of statutes to the Legislative Reference Bureau. And inside government, the whole rulemaking process, there's a lot of discussions. Nate and I spent the better part of 2 hours at training session on rules in December.
Exciting training session, I might add.
I'm not sure if I'm getting ahead of the discussion, but I found in some of the attachments, and maybe the attachments are simply a statement of the proposed rule as they then existed. But on page 111, for example, there's reference to Shane Falk as staff counsel as the agency contact person.
Yeah, these were
And
I'm sorry.
is that old material that's simply added?
That's right. If you look at the memorandum, you know, and it says, it refers to attachments A, B, and C, those were to illustrate what we were talking about for the board members, so that they understood. So attachment B, that is the scope statement that that was prepared for election observers, and that's the one we would do, since we have to start that one over again because the legislature didn't act on her rule. Or attachment C, it gives an example generally of what a scope statement would look like. So again, those are all different examples, and they're all existing documents. You're right, it'll have references to prior staff on them.
Okay. What about the settlement offer schedule? In reviewing that there appear to be some typos in it in terms of percentage of salary of office as a penalty. In some places it's 1%, in some places it's 0.1%.
In one place it says salary, and the rest of the places it says annual salary.
And there's a typo, I think, on page 112, under definition of the board. To be consistent with everything else, Government Accountability Board should start with caps.
Actually, that's a drafting technique that they have for us, that it doesn't go in caps.
In the rules.
In the rules. I mean, like I said, there's a whole drafting mechanism, but the other typos are matters that we'll make sure get fixed before they're actually submitted, the 2009 one.
Right, these were from 2009, and I'm not sure how many review processes this went through before. This was just more of an example of what it, looked like back then, so maybe it's not as helpful. But yeah, we will look at the typos on here,
Are each
obviously.
one of these mentioned on page 90 in tablet 27? Every one of them start out with a new scope?
Some of them do. The only ones that will not need a new scope are the electronic voting equipment security and the requirements for electronic voting systems. Those have scope statements that were submitted in 2013. We have a 4-year period in order to get the work done. The other ones will be new scope statements.
And just to clarify, I'm not sure who exactly said, but we're not asking the board today to approve any text, only to direct staff to submit a scope statement, which will be submitted to the governor, and then will come back to the board for approval after the governor has approved it.
It will be a general statement, when we're talking about scope statements. This materials are what have been drafted in the past. My understanding is these materials will not go to the governor's
Nope.
office.
They're provided purely for illustration of what these areas will look like, the different work that has been done previously.
And I think, in fact, for example, on the forfeitures, the settlement schedules, we would have different recommendations for the board in terms of rule adoption at this point. But it would just say to the governor's office, we want to adopt a rule with forfeiture schedules, or we want to adopt a rule that addresses such and such an area.
The statute book I got in my office at home is from 2008, and it says to the Department of Administration. Has that been changed?
Yes.
The governor?
Yes, it has.
Oh, okay.
In 2011, the legislature made a total rewrite of how the administrative rule process goes, and then the governor also issued an executive order with even more detail about this, how to comply with these things. So it's a minor subcategory of expertise.
Okay.
on putting these rules together. It's also one of the reasons why when allocating our resources in 2011, 2012, and 2013, it was like, which fire do we put out first? And these rules went further down because they didn't seem to have as pressing a demand as, county recount petitions.
Now because they're all pressing, is that right?
Exactly. Well, and also I think we've got more time to get it done than we did then.
Okay. Any further discussion? We're ready for the motion on page 97, the recommendation, to approve the recommendation on 97.
I'll make the motion that we approve the recommendations 1 through 4 on page 97.
And you made a slight change in 4.
And 4, to direct staff to take steps to repeal administrative rules identified by the LAB through its audit that were not adopted.
Remove rather than repeal.
I'm sorry, remove, that's right.
I'll second.
Okay, that's Judge Frankie.
Judge Byron seconds.
Oh, I'm sorry.
Well, whose motion is it?
It's Judge Nickel, seconded by
Yeah,
Judge.
are you calling a vote?
Not yet.
Okay, can I ask, just to be clear, then 4 is being amended to take out the word repeal and
And,
substitute remove.
and to take, board directs staff
Take
to take
steps.
steps to remove.
And all right, that's fine. And if that should somehow need board
You'll come,
action or resolution, we'll have to deal with it.
that's right.
Any further comments? You all understand the recommendation?
Yes, sir.
Let's have a roll call vote.
Okay. Judge Barlin,
Aye.
Judge Frankie,
Aye.
Judge Lemalis,
Aye.
Judge Nickel,
Aye.
Judge Volkey,
Aye.
Judge Freilich.
All right.
Motion carries. Now, we're on to the proposed legislative agenda. Thank you, Nate. And we have John Becker and Brian Bell. And we had 2 subcommittees, and I will note that on the campaign finance revision resolution, it was Judge Freilich and Judge Barlin who worked with John Becker. And on the recommended changes to lobbying and ethics laws, it was Judge Volkey and Judge Frankie. There was, the memo you see on page 132 was annotated by the subcommittee, and that was just sent out to you by the board members. It has, just reflects comments of the subcommittee, and I will expect that Judge Volkey or Judge Frankie can talk about those annotations.
Judge Frankie will be happy to.
So this is Jonathan, and with me is Brian Bell. I drafted, pursuant to the board's request at the last meeting, this resolution. You all should have received from me an email. There was a typographical error in what I sent out, and actually sense the way I sent it out, and that is on the second to the last bullet point under the resolution. And it should have been adjusting or eliminating, and that was Judge Freilich's suggestion, rather than the word limiting. And so I made that correction, and I hope everyone received that email from me. I think I sent it out last Friday. And
What pages are you referring to, John?
I'm sorry?
What pages are you referring to?
Top of page 131, Judge.
Yeah, 131. And it should read adjusting or eliminating Judge Freilich's suggestion, and that was the intended word, but somehow limiting got put in by me rather than eliminating. And that should read adjusting or eliminating. Actually, the changes that Judge Freilich and Judge Barlin are relatively few.
But, so what you have in your materials is the version that has been reviewed by the two judges that incorporates their suggestions, but for that one typographical error, and that correction was sent under separate email. And this really reflects the board view that in addressing campaign finance laws, that rather than some of the very specific pinpoint recommendations that staff had originally come up with, that the board believed the legislature should take a broader view and approach to the campaign finance.
You know, I reviewed the minutes from our meeting when we discussed this, and I've looked at the memorandum. And I have to remark that I think certain people have taken comments out of context, cherry-picked, if you will, which is a type of argument in which people look at the whole, ignore what they want to ignore, and simply take parts of it. For example, I was quoted as saying that something to the effect that some parts of Rule 11 seem to be unenforceable, the words to that effect. And some people, I think, have erroneously jumped to the conclusion that this institution, the GAB, thinks that the entirety of Chapter 11 is unenforceable. And that certainly wasn't the intent that I was trying to convey. I think Judge Barlin, as I recall, simply indicated that rather than doing a review of this, we'd recommend to the legislature that they look at it all rather than simply trying to cover a hole here and there. So if I did here before, I want to make it clear now. I think the legislature should take a look at all of it because it all fits together. Some of it is very understandable, but we've also got rulings from courts which had made it clear that some parts are unenforceable.
I concur in Judge Volke's comments.
I want to add, at our last meeting, when Judge Volke, Judge Barland, and I all made various comments about the state of campaign finance laws in Wisconsin, we had a list of recommendations that the staff had put together, and while I do think that a comprehensive approach is best, as I stated then, the staff had very good suggestions about what needs to be done and changes that should be most likely incorporated to reflect the current state of the law. And as I was thinking back on that, I thought there was a great deal of work that the staff did that because I think all of us agreed that a more comprehensive approach was necessary, we didn't sufficiently acknowledge the work that the staff had done. And I wanted to remedy that as well. And I was thinking about that in the context of the resolution that is being recommended at pages 130 and 31. And I was thinking also about the various articles that I have been reading about the inclination of the legislature to rewrite Chapter 11 and the inclination to move on that endeavor relatively swiftly. And while I agree that a legislative council committee is a sound way of going about it. I do have a concern as to whether or not there will be enough time for a legislative council to act. And so I've been thinking about all of these matters that Judge Volke and Judge Barland have just brought up. And one of the things that I wanted the board to consider is whether or not we might wish to add some language about this, about our position with respect to campaign finance law beyond a legislative council study committee, which I think is what we talked about at the last meeting. And so one of the things that I wanted to throw out is to see how other members felt, is whether or not, in addition to the change at the top of 131 with respect to contribution limits, we may not wish to add a paragraph number 3 that would state something I penciled out as I was thinking about this, but I'm just throwing it out to see how other members think of it. Something along the lines of whether or not a legislative council study committee is created, the board being persuaded that revision of campaign finance laws necessary, offers its assistance, experience, and cooperation to the legislature in connection with the revision of Wisconsin campaign finance laws. And one of the reasons that I came up with this language is, as I've stated, a concern that the legislature may go forward without a legislative council study committee, and our staff, that list of proposals that were presented at the last meeting and that were very detailed, there's a lot of good ideas there, and that we want to communicate to the legislature that even if no legislative council study committee is created, we support efforts to revise campaign finance laws, and that we have a staff that's got a lot of experience and depth in this area. I kicked this around. At the same time, I thought, well, perhaps adding such language would undermine the request or the support for a legislative council study committee, and so I don't know how others will feel, but I did want to float that as a possibility.
Well, as a follow-up to, this is Judge Barland, follow-up to what Judge Lemelis has said, I have gotten the impression in, talking to some legislators that the legislative council approach has not been used as much recently as it has been in the past. A concern I have about revision of Chapter 11 is that it be given thorough and complete study and consideration, and usually that's done through some sort of a study committee that has to meet a number of times. And I've gotten the impression from what I've heard informally and what I've read in the press is that the legislators concerned may have the impression that Chapter 11 can be rewritten rather quickly. And I don't think so, because it's a profound area of election law. There's a lot of issues that are there. It's vast in scope, And the worst thing that could be done is either a piecemeal change or a ill-informed change. So I guess I share Judge Lamelas' concerns that she just expressed.
So where does that leave us?
Concerns when we're addressing this is that when we're asking them to look at a revision of this chapter as it deals with campaign finance, is that the position that this board has taken in various pieces of litigation that have been in which they've been involved in, involving coordination, stays put. That is what the law is at the time that we have maintained our position in those lawsuits and in that litigation. And by the fact that we're asking for revision does not weaken or in any way affect our position in any of that litigation.
Should that be stated someplace in the resolution or not?
I would like it to be.
Yeah, I agree with Judge Nichol.
I'm not sure that I could support that. And the reason is that while the board has taken certain positions at certain times, with the passage of time, our understanding of the law has changed. I think, and maybe not just our understanding of the law has changed, but the court's interpretation of the law has been moving along. This is an area of the law that has been in recent years very much in flux, and so I would be concerned about that.
This is Jonathan. You know, as a practical matter, there's no need for any of those whereas clauses, and those seem to be the ones that are creating some ambiguity or raising issues that I don't think the board meant to raise. The sum and substance of this is what the board wants the legislature to do, and I think that the whereases are kind of obvious to everyone as to why that is. And maybe a way to address this issue, if you want to retain the sort of the basis for the board's going forward here, is, and remember, this is language I came up with, and that's perhaps to get rid of the third number about, this is difficult or convoluted. It may or may not be, and it certainly may or may not be in whole or in part. The other stuff is true, that the law hasn't undergone a revision, that there are these federal court cases, and that the board thinks that the best approach is a thorough review and revision. And that sort of gets rid of that issue of what we think is still, what our position is or wasn't, and that sort of thing.
I think that's a good point. I think when Chapter 11 was passed, it may have been fairly easy to understand, but we've had Citizens United, we've had Seventh Circuit cases, and as Judge Lamelas says, the law is definitely in flux. And these decisions are affecting Chapter 11, whether they're intended to or not.
But the language of the statutes haven't changed, and we've been able to administer and enforce them since the mid-'70s. So maybe that's not the issue. They've become convoluted and difficult because of the court cases, not because of what's inherent in the statutes themselves necessarily.
I think you're right.
And quite honestly, I think lay people would find most of the statutes difficult to understand and follow. It's just the way statutes are written. Lawyers understand them, though, and sometimes, and sometimes judges even.
We don't have a
motion
we don't have a motion at this time. I mean, we don't have a movement.
But what I might suggest to the board, up to the board, of course, is to not include paragraph, the third whereas, and perhaps to add at the end a number 3 along the lines that Judge Lamela suggested, which would read, whether or not a legislative council study committee is created, the board, when we just say the board offers its expertise and experience in the redrafting of the law.
Would that eliminate, would striking the as eliminate Judge Nichols' concerns about, Judge Nichols, I think, wanted to add a whereas that I might have a problem with, but I'm wondering if by eliminating the third whereas, Judge Nichols' concern is alleviated about not adding a fifth or fourth whereas.
I suggest we take this in steps, and I would move to delete the third whereas clause.
I'd second.
Any discussion on that issue? If not, call a roll.
Judge Volkey?
Aye.
Judge Nickel?
Aye.
Judge Lamelas? Judge Frankie?
Aye.
Judge Barlin?
Aye.
Judge Freilich?
Aye.
Motion carries to eliminate the third whereas clause.
I'd also make a motion to incorporate the language of judge as a 3 on page 131.
And that language is what?
Can you read it back to us, please?
What I had written, what I had penciled in on my version is whether or not a legislative council study committee is created, the board, being persuaded of campaign finance laws is necessary, offers its assistance, experience, and cooperation to the legislature in connection with the revision of Wisconsin campaign finance laws.
Assistance, experience, and what?
And cooperation to the legislature in connection with the revision of Wisconsin campaign finance laws. And I really toyed around with this language because I kept thinking, who are we to be all? Of course we have to help. You know, we're a creature of the state, and we're required to help. But I wanted to signal our willingness to help in what is a very complex area, in light of our recognition that something has to be done from the ground up. And I wanted to be on the record with that, so that no one can say, as far as we're concerned, council way is the way to go, and after that, you know, we're going to drag our feet or not join in and not help out in what is a very important endeavor, and I think is consistent with what Judge Barlow said. This is a profound and complicated that may not lend itself to the quick fix that some people think can easily take place. I mean, the only quick fix that I can think of is eliminating the whole darn thing, and I'm not sure that the legislature wants to do that, but that's obviously up to them.
Well, to motion was to incorporate the languages of subpart 3, which was just recited to us by Judge Lamelas.
And so you've made the motion?
Yes, sir.
And the second is whom?
I'll second.
Judge Nickel seconds.
And so, did Judge Volkey just state the motion?
I did indirectly by stating what Judge Lamela's wording was.
I'm having a little trouble hearing you. I don't know what cuts in and out.
It was stolen from me about 10 minutes ago.
Now I can hear you.
Thank you. Yes, my motion was to incorporate as a part 3 on page 131, the language utilized by Judge Lamalis.
If there wasn't
That's
a
been seconded.
It was
Okay,
seconded
so-
by Judge Nickel.
Okay.
I think we're ready for a vote. Do we need a roll call vote on that? I don't think so. Everybody signify by saying aye for the amendment.
Aye.
Aye. Aye.
Opposed? Unanimous.
And now I think you would need a
motion
motion
on
on the amended
Yeah.
resolution.
I'd move that we adopt the amended resolution.
Is there a second?
Second?
Second is heard.
That's Judge Barlin?
Frankie?
Yes.
Frankie? Oh, okay.
I made the same mistake.
I did too.
And that would include the typographical correction on
Yes.
the second page.
Speak up, John.
That would include the typographical correction on the second page first.
Any further discussion? All those in favor, call the roll. Signify by saying aye.
Judge Volkey?
Aye.
Judge Nickel?
Aye.
Judge Frankie?
Aye.
Judge Lamalis?
Aye.
Judge Barlin?
Aye.
Judge Freilich?
Aye.
Motion carries.
Move on to the ethics situation.
Judge
On page
Frankie, since I'm here,
132.
would you like me to address it?
Sure. I'm maybe running into a time problem. I need to leave for the airport in a little over an hour. Are we? I don't know how long the closed session is going to take, but let's see if we can get through this. Yes. Go ahead.
Judge Frankie and I met together several times last week by phone and discussed the memorandum that was prepared by Materials. Hopefully you've gotten a copy of it today, which has Judge Frankie's comments under each of the subparts in red. And if, Judge Freilich, you've got it. Okay, good. What we did is we took these 19 different subparts, paragraphs, and we put them in one of three categories. Category number one is something that we would suggest that the GAB strongly recommend. Number is a category where we would simply make a suggestion. And number three is one where we point out to the legislature that we think it's a policy decision that's simply made by the legislature, and we're not necessarily. So to do this, we are saying that 1, 3, we would recommend taking a strong position on 2, 6, 7, 8, 9, 10, 11, 13, 18, and 19 in support. And finally, we would simply suggest, and 15.
Must be made or should be made, and then there could be another section that would say something like, these are issues that the the legislature should address to determine what action it needs to take, or something along those lines.
Yes, we could divide it into the 3 different groups. And I would suggest we start with the ones that we strongly recommend, and the last group should be something that the legislature clearly understands we think's within their purview and not ours.
So how do we want to start this? Do we want to go forward today, or do we want to redraft this thing in sections? Or?
I think that we could simply, presuming that everybody agrees with Judge Frankie and I think we could simply have the statute number, put it into number 1, those that we strongly recommend, number 2, those that we suggest, and number 3, policy. And the only thing that I think it's necessary to add is an explanation as to why, what strong recommendation is, what suggestion is, and that we think something policy subject to the purview of the legislature and not the GAB.
Do you want further explanation for these? I mean, I think right now the way this is written, it says, well, let me ask you, do you believe there's enough explanation within what's written here as to why the changes are being recommended, or do you feel that needs expansion?
I would not expand.
Okay.
I would try to make it pithier, rather. Explanations can come later in a separate memo, but if we want people to read this stuff, the less, the better, I think.
The KISS principle.
I agree, and I have brief editorial suggestions. On the first page, where under background, that opening sentence needs to be rewritten. It's not very clear. It doesn't have any punch, and
the whole paragraph is too long.
yes. And then the second, on page 134, item 9, it wasn't clear to me exactly what the possible change should be. And on the same page, item 11, there's a parentheses in the second line, or that no further action is warranted, and I think period, parentheses closed. I didn't see a close to that parentheses.
Not closed. Quotation marks, right.
Quotation mark, yeah.
Yes, I meant quotation. Misspoke.
Can I point out one other thing for board members, and that is and I think that you might want to consider changing the category or holding off on that one until we've had some more discussion.
But are we proposing, I think what they want is to be involved in the specific.
If this is proposed language, it needs to be cleaned up, some obsolete language, some typos. I'm not going to go over them now, but I saw quite a number of points on those pages that need to be reworked.
So what we can do is we can take a careful look at this, group the suggestions into the categories created by Judges Vokey and Frankie, make sure that language and spelling is all cleaned up, maybe get this out of the board materials for the next meeting to give the board plenty of time to look at it, and then at the next meeting the board can then concentrate on, do you agree or disagree with Judge Frankie's and Judge Vokey's recommendations on each of these, and kind of focus then on the substance.
Well, wouldn't it be better to approve what Tim and John have done in terms of these different provisions, and then allow the staff to do further work, but I think we need some approval of their report and their recommendations. That would be my motion.
Well, conceptually, I mean, I don't think any one of us have any disagreement at this point with anything that's been recommended. But it's hard to say that all of us are signing up to absolutely everything that's on the memo. But I think conceptually, they've done really good work and have really advanced advanced the ball. I think it's much easier to see the changes that could and should be made because of what's on this memo. So if what, Judge Nickel, if what you're looking for is some sort of statement of conceptual support and request for reformatting, I can sign on to that.
You can sign on.
Pardon me?
I said you can sign on.
Yeah.
Take it in a second.
You know, what we at staff can do is, I mean, if the board basically takes the position that they endorse this, we will clean it up, and then we'll send it out to all the board members. And we can do that relatively quickly, because I do think that it's best to get stuff to the legislature as soon as possible in the session, and then board members who have any individual suggestions for further cleanup can contact staff, not each other, but, you know, because there's open meetings laws to consider, contact staff, and then we can proceed with conveying that to the legislature at that point after the board members have weighed in.
And the only caveat I would add would be that after the board members have weighed in, that Judge Nickel, as chair, sign off on it.
So there would not be any other consideration of this at a meeting?
That's the question.
So this is Brian. When I first drafted this, the background introductory sections were really meant for the board and for the public at first, but I think it sounds like if there's a consensus on Judge Vokey's and Judge assessment of each of these changes, we could reconsolidate the memo with just a very succinct introductory sentence saying that the board met and has organized recommendations in these three categories with a brief explanation of each, and maybe a statement similar to Judge Lemanis, which you made on the last motion, that the board's available for further assistance so we can communicate this to the legislature in a timely manner. And then if they have follow-up and they want to pursue any of these, you know, we can report back. And
It seems to me that once it's circulated, if anybody wanted to have a meeting on it, Judge Nickel could call a special meeting by phone for that specific purpose.
I'd be happy to do that.
So if you got a couple people comfortable with proceeding without a meeting, Judge Nickel, you could call the phone. Otherwise, if you don't hear anything, you could just sign off on it. That would be the way to proceed?
That would be one way, but also in terms of communication. If you have some suggestions based upon what they put out, I'm talking about the staff, then we should do that by email. Reed or Kevin can share it with us all so that we all informed and nobody's acting on their own.
I think we need to clarify the status of the specific recommended language for 13.625. It was my suggestion that we separate these things and that the memo we're talking about and the list of recommendations under sub 2 not refer to any specific language. And I'm not suggesting we need to pursue specific language, but if the staff wants to, with respect to 13.625, do that, we should just deal with that as a separate issue, because the The memo we're talking about is a list of recommendations without specific statutory language.
That's right, and if we do that, that takes away the concern of the Association of Wisconsin Lobbyists.
Yes.
And that was the understanding I think the staff had going forward, that that would not.
Okay.
Before you're done, I want to go to 13 on page 134. I want to know how that changed by adding legislators elect to the statute for, how does the purpose of clarity and simplification? I don't think that makes any sense. You're adding a new category. How does that simplify anything?
Well, here's the way it simplifies it. Once a person has been elected, even before they assume office.
I agree with what you're saying.
Yeah, well, they're subject to
I
the.
think the wording is,
Oh, I see
somebody
what you're
look at
saying.
that wording and say, how does this make it more simpler?
It doesn't. What it does, it sort of makes it consistent with the lobbying law, is really what it does. Because under the lobbying law, you're subject to the lobbying law and taking
But
gifts.
that's not you can't understand that by reading that word.
No, you're absolutely right.
I think those words should be taken out. I mean, I support the idea.
Okay, so we'll just take that out. We don't disagree here.
Okay. Excuse me for interrupting.
You're the chairman, you can do that.
You are
So
running
no,
the
I'm
show.
not.
You're running the show.
You're running the show.
Just to clarify, that's to strike the wording for the purposes of clarity and simplification.
Yeah, you can add some other words maybe to help that sentence make more sense.
Sure.
Not clarity and simplification.
Yep.
Certainly.
And this is an example probably of the kind of edits that after we've done this, we will see some additional ones.
Okay, does everybody understand the motion?
Well,
I forgot.
I'm assuming that Judge Nickel and Judge Lemalis have moved and seconded
Right.
this process.
Well, I didn't know, but what did I do? Did I move it or did I
You
second
said
it?
you said you're on the same page.
Oh, yes, I did. I stand corrected.
So that's the same as the second, right?
Right.
Yeah, read my lips.
Well,
Okay.
actually, when you said you're on the same page, Judge Freilich said that means you should second it.
I second it.
Okay.
Is that what you want me to do here?
Well, we just want to be clear that that's what the record's going to reflect.
Okay.
And the motion and second is to direct the staff to rework this document, share it for comments with the board members, and then present it to Judge Nickel before it goes to the legislature, or for Judge Nickel to make a decision whether or not a special meeting is needed.
Is required before we then send it to the legislature.
Okay, I think we're ready to vote. All those in favor, please call the roll.
Judge Barlin,
Aye.
Judge Frankie,
Aye.
Judge Lemalis, Judge Nickel,
Aye.
Judge Volkey,
Aye.
Judge Freilich.
Aye.
Motion carries. The last item on the agenda is the director's report, and there's nothing really pressing to add that we haven't already talked about, other than to say I've been in touch with the audit committee, and they'll be getting me the information for the call-in for tomorrow.
Then I move we go into closed session.
Second.
Second?
Okay. We will be taking about a 5-minute break.
You have to call it.
We may need to be a little more than 5 minutes for Wisconsin and I to get their stuff out here. Can we say 10?
We'll say, can you do it in 10 minutes?
Yeah.
10 minutes. But we're going to take a roll call vote first, I guess, on this. So, Judge Barlin,
Aye.
Judge Frankie,
Aye.
Aye.
Judge Nickel,
Aye.
Judge Volkey,
Aye.
Judge Freilich.
Aye.
When do you leave for the airport, Judge Frank?
Well, that's just, I got something I wanted to get shipped out by UPS before I leave. I need to leave for the airport, trying to think of what traffic is like at the latest, say, 3:45. My time.